Here are some of the best defenses to intoxication manslaughter charges. Intoxication manslaughter is one of the toughest cases to be prosecuted for. Individuals charged with intoxication manslaughter typically have no criminal history. They didn't set out to hurt someone, and yet they're faced with a prosecutor who is driven by the fact that someone lost their life as a result of your actions. The punishment range for intoxication manslaughter is 2 to 20 years in Texas, and prosecutors are generally thinking about offers in the double digits in prison time. Just because you have no criminal history does not mean a prosecutor is going to be looking at that case saying probation might be appropriate. You're generally up against very, very harsh offers, and this is a unique type of case where the probability of going to trial is much higher than it would be in other cases. So what are some of the best defenses in intoxication manslaughter cases? First and foremost, we want to find any weakness possible in the underlying intoxication charge. Understanding that most intoxication manslaughter cases involve an accident, and there's generally two vehicles. Of course, there are intoxication manslaughter cases involving pedestrians, but most of them involve multiple vehicles. So an officer is generally coming up to a stopped vehicle. In some instances, such as instances where the accident was with a pedestrian, the officer might actually initiate a traffic stop. If a traffic stop was initiated, we need to look at whether the officer had reasonable suspicion to stop you. And generally speaking, with something this serious, the officer will have reasonable suspicion. But our attention really turns on whether the officer developed probable cause to arrest you. Officers are human. When they see that someone is seriously injured, dying, or has deceased, their instinct is to assume, particularly if they smell the odor of alcohol, that you're intoxicated. And they start making some pretty quick judgments. They sometimes don't properly develop probable cause to arrest you, or ultimately enough information to show that you were intoxicated. In Texas, we generally don't see portable breath tests at the scene. Even if there's a portable breath test, it's only used to show the presence of alcohol. It can't be used to show what your alcohol concentration was. So probable cause really depends on the driving behavior and the officer's observations, whether you did field sobriety tests, how you did field sobriety tests, whether you answered questions, what statements you made, what admissions you made. They might also have reports from other drivers or witnesses who saw the accident. As your attorney, we're analyzing all the facts to see if the officer actually developed probable cause for your arrest. Because if they didn't, then potentially everything that came after that arrest could be kicked out by the court through what's called a motion to suppress evidence. The next thing we'll take a look at is how a specimen was obtained in your case. Typically, intoxication manslaughter cases involve the drawing of blood to show what your blood alcohol concentration was. That blood may have been drawn by consent, or you may have refused to give consent, which is what we would advise you to do, and that forces the officer to go out and get a warrant to draw your blood. If a warrant is drawn up, then we look for mistakes in the affidavit for search warrant, because once again, officers might make mistakes, particularly if they're in a rush, and particularly if they have already formed their judgment that you're responsible for this intoxication manslaughter case. Once the results are obtained, we'll take a look at what your blood alcohol concentration was at the time of the draw, but also what it would have been at the time of the accident if that retrograde extrapolation can actually be conducted. Retrograde extrapolation is the somewhat fuzzy science that prosecutors use to do that calculation. The critical question that the officer had to ask in order for that calculation to be even remotely correct is, what time was your last drink? So if that answer wasn't correct, or if that answer was never elicited from you, then prosecutors may not even know what your true blood alcohol concentration could have been at the time of driving. That's a weakness that we would want to use in your defense. We'll also look at all the medical records and the autopsy report. We've had situations before where the deceased, the other driver, actually had controlled substances in their system or alcohol in their system. That's something we would want to know and potentially use as a part of your defense. Ultimately, intoxication manslaughter cases are very tough cases because prosecutors have very strong feelings about the cases and the underlying facts. You need an attorney who will leave no stone unturned in your defense. You need an attorney who cares about you and getting to the right outcome in your case. And ultimately, you need an attorney who can convince the prosecutor, or potentially someday a jury, that prison is not the appropriate outcome in this case. This video was made in response to a question we received on this channel. If you have a question about criminal law in Texas or federal criminal law, drop a comment below and we'll be sure to answer that. You can also check us out at versestexas.com.